Okay, my name is Jay Chauhan. I'm the mentor at the Angel Mentorship Group. And today's topic is on the question of sale of shares, which we are actually doing with a couple of members of our group. And so I want to address that issue in terms of how we can carry out the sale of shares in any company. So the first issue is how does the problem first come to the lawyer? So in this particular case, the way it happened was that one person, the two persons who owned the shop had a disagreement. And so the person who is our client bought out the shares of the other person. So when he bought the shares out, I was the independent counsel acting for the purchaser of the shares. Now, Deep, I'm in the middle of the seminar. If you want to join, you can, but I'm in the middle of seminar. Okay. Sorry about that. So I think in terms of the issues in this particular file, we have a situation where the client bought the shares, and now what we're doing is from our group, actually, we will prepare the documents for the sale of the shares. So first I want to just point out the responsibilities of the vendor and the purchaser. The major responsibility of the vendor is to convey the shares and transfer them effectively to the purchaser. And there are two major types of share transfers in a small company, which you will get in a suburban practice. And we're not dealing with very large corporations in a suburb, but in a small company like this particular one, we are not dealing with the concern of all the history of the organization, that the purchaser does not know what he's getting into, and therefore the concerns of the financial statements and the concerns of the history of the organization and the liabilities is not a major concern, because the existing partner already knows, actually. So there's a big difference in my mind between the share purchase in a small company and the share purchase in a bigger company, meaning that when you buy out the whole company, you have to worry not only about the shares being transferred properly, but all the properties. And if you're buying a motel owned by a corporation, for example, you must know that the title to the real property of the motel is also correctly on the register in the registry office. So having said that, I just want to explain to you that in this particular situation, our role will be that of the vendor. But I want to cover in this talk today both the position of the vendor and the position of the purchaser. As I mentioned earlier before we began this program, that the responsibilities in the common law are based, and all the rules of professional conduct are based on that very fundamental principle that the role of the barrister or a lawyer is to protect his particular client. And this continues in the confidentiality situation. It continues in your obligation to the client. It continues in the sense of loyalty that you owe to particular client. So you have many, many rules of professional conduct which are aimed, I would say almost 75% of the rules of professional conduct are aimed at particularly pointing out to the lawyer his particular duty, which is different than the civil law. And I think that, so just a broad distinction between the sale and the purchase of the shares is that if you're the seller of the shares, then the main thing you're concerned about is that you draft the share transfer arrangement. You also may be required by the purchaser lawyer to say that you'll make representations and warranties in the share purchase arrangement. And these representations and warranties would include the financial statements and how did your company perform. And if once your agreement is made, then the purchaser lawyer commences his searches, and the searches are much more than just the real estate search. I'll go through that a little bit down the line, but it's very important that the key distinction between the vendor's obligation in a sale of shares and that of the purchaser is to essentially the vendor to convey the shares, and if there's financing arrangement, for example, a promissory note or a payment in cash, then all of it are completed on the date of closing. So you have the key elements of a purchase agreement, which is that what is it that you're selling, which is the shares. The shares may be 20% or 50% or 70% of the company, and the purchaser is getting this representation, but notwithstanding the representations, is also checking all the issues that he needs to check. For example, Personal Property Security Act, the executions as they're called actually, which is judgments against the vendor, etc. So these searches are done by the purchaser. So what is the obligation of the purchaser's lawyer? He, in the representations and warranties, will look at the representations and warranties as spelled out in the purchase agreement. But then between the date of the agreement and the date of closing, there is a time gap, because this time gap is there for the purchaser's lawyer to try to do the searches that he's required to do. And there is an exhaustive list actually for which you can use in a corporate law, which I'm sure that you have, Kevin, in South Africa jurisdiction as well. But here in Ontario, you have quite a number of things that you can check, which is unlike the real property search where you have the title and the Land Titles Act or Registry Act, where you look up the ownership and the mortgage, and you more or less have an idea who owned the property. Then you might be looking at the zoning and the bylaw compliance, in which you are also checking to make sure that if you have a house or a property on a location, that they are correctly in compliance with the bylaw requirements. So these, as the law evolves for planning act, for example, in real property, it affects the title of the lawyer, because the client is looking to you to give on the purchaser side a good, clear title. So the word used very often in the report that you'll see printed very often from the mortgage companies, for example, is that you certified to the title, good and marketable title. A major change that has happened in real estate is the insurance arrangement that actually certify the title and then dictate to you what you will do to check the title. But I won't go into that right now. When we deal with the motel purchase, I will go through that at that time. But for the purchase of shares, it is important to note that if the vendor had a judgment against him, that judgment can attach to the share and therefore can be encumbered with the encumbrance. But if you want my observation in practice, very rarely is the judgment attached and connected with the obligations of the vendor to pay off the liability to the third party, the creditor against who's got the judgment, and very rarely attached. But if you're doing it in real estate, for example, today in TerraView, you will see that you're able to look at the particular person having a judgment, and all of them they used to be organized around the registry offices of the county, and they're now on the computer for the whole of the province. So you're able to check out the judgment and executions instantly. But still, my understanding is that this is checked within the county or the jurisdiction where you are located. But I think you're able to now check the judgment against the person in the whole of the province. So I think that is important for the purchase lawyer to check out what are the encumbrances. And then another major encumbrance that you might have to deal with is the question of Personal Property Security Act, which is a register kept at University Avenue. But these searches can now be done online. So what we do typically is that we take the list of searches, give it to a title searcher or a paralegal, and he carries out the search and then hands it to the lawyer. The lawyer makes the evaluation and then basically decides to make a requisition letter. It goes to the vendor lawyer. He replies to the requisition that the name sounds similar. You can have an affidavit saying that this is not the same person. That principle that you have in real estate also applies in sale of shares as well. So I think my first topic of what is the sale of shares it should also be seen in the context of what you can tell the client. The client does not come with the neat categories that are taught in the school. That what would you say to a client who says that I want to transfer the shares? So should you then talk about the ways of conveying your property? You can, for example, convey the whole asset that you want to deal with. Suppose you have a shop, a grocery store, a hairdressing shop, or you have any other company that you own. Should you sell it by shares or should you sell it by assets? Now, today we won't have enough time to go through the distinction, but there are major tax differences, and then you have to have sufficient amount of understanding in the corporate law for the purpose of deciding in your mind that what would you advise the client to do. In my case, if the shares are being transferred because the vendor insists on that for tax reasons, the corporate legal entity, which is like a minute book, and the legal corporate entity as the financial statements go along with the sale of shares. So even if the shareholders change by the sale of shares, the corporate entity remains the same. And therefore, if your tax liability is most important to note that the tax liability of the corporation continues regardless of the fact that the share ownership has now changed. Is one very important thing to remember, and that can be overcome by essentially getting a representation from the vendor that if there is a corporate liability for tax payment, that the vendor shall remain liable until the date of closing. The other issue that is important to remember in the share purchase agreement is that if you're transferring the tangible real property type of an asset, then you also have to make sure that the title of the property is properly in the name of the vendor, and that the vendor has a right to convey the property so that the vendor who owns the share also either through the corporation or his own name able to transfer the property to the purchaser. So these are the key elements of the sale of shares that are extremely important. So I just want to pause for a second. And so the agreement point of view, does anybody have a question? So if there is no question, then I just want to, frame the question for you. See, let me see if you know the issue. When a lawyer gets an agreement in his hands in a small company, how does the client begin the process of selling a company? Is a lawyer involved? Or if anybody has a comment, and I want to hear from you actually, then I'll give you my comment of many transactions that I've gone through. How does the client initiate? And this is not taught in the schools, by the way, so therefore you have to see from experience, how does typically a transaction end up with a lawyer? Is it directly because the client says, I want to buy this company, and you draft as a lawyer the purchase agreement? Or is it a client? If it's an agent who has actually acted as a broker, there is a separate statute, Real Estate Business Brokers Act, under which he's acting to carry out his duty to sell, then hands over the transaction to the purchaser. So if anybody has a comment, then I want to hear your comment in terms of your observation as to how it comes to you actually. So this affects the way in which you market your practice as well. So are you going to wait for the client to bring you the purchase agreement? Or how do you build a practice around the question of the corporate law? So if you are in a fortunate position like Kevin, that you have a boss who is absolutely ready to give you and keep you busy from 9 to 6 o'clock every single day, then you got it made. But if you haven't, then you have to be busy like me to look around to people and say, who is got a company to sell and who is going to transfer the shares? And I want to talk to you so that when the time comes, I'll quote a fee to you, and that fee will become more important to the client than all the title issues that we discussed in the law school actually. So if you have any comment, I want to hear from you. If not, then I'll just move to the second topic of from agreement to actual physically transferring the shares in a company. So I've got somebody coming into the group. Yeah. So if no questions, then I will deal with the second issue. What are the documentation? What is the documentation that you need to deal with on a share transfer. So I think that if anybody wants to comment on it, then I want to just open the floor so that I want to make this as interactive as possible so I get an idea actually where you are at in terms of your learning or observation, and then I will continue. So any questions? If not, then I'll talk about the documents that you need to do the transfer. Okay, so no questions. I'm going to move on to this question actually. What are the documents that you will need? Very often, the way we go and learn in the school, I did this before we recorded this program, is not the way in which the client actually comes and frames the question to you. So the biggest challenge that a lawyer faces in launching a practice is understanding the documents which you have to prepare, the sequence in which these documents are going to be organized, how you're going to draft the agreement will then affect you, the studies, the JD or LLB or NCA, that will affect you at that time when you're drafting the middle. It'll spring up in your mind that this is what the Business Corporation Act said. So I think I just want to go through the major documents and I'll describe each one. And if you have any question in that regard, then feel free to sort of interrupt me and then I will hear you, because I want to understand actually, because it's been too many years, since almost 48 years since I've been practicing, so I've forgotten the difference between what is taught and what is it that you need to know to carry out the file. Yeah? So what I think is common knowledge and the part of the JD degree is not necessarily the case in my mind anymore. So I do want to hear whenever possible. So let me just summarize to you that in this particular file that we're dealing with, the following documents are relevant in terms of the way in which you would conduct the sale transaction, because after the purchase of the shares by our client is trying to sell the shares to the purchaser, who is a new partner, and what does he want to be able to do? So firstly, you have a share purchase agreement, which we talked about, with representations and warranties that we talked about actually, and the second one is a shareholders agreement. When you learn the JD degree or NCA degree, or you're a member of the Lincoln Sin or Inner Temple, what happens is this subject of a shareholders agreement is usually in a seminar a separate independent topic, totally explained. It's not mixed up with the purchase agreement. But I can assure you, and I think it's very important in my mind to explain to you, that you have to be ready immediately to tell the client and have it in your mind ready to explain to the client that if you are selling the shares in more than 50%, then you're giving the right of control over who will be the director of the company. Now what is the controlling point, and how does it affect the company? There is no, to my knowledge, no board mission notes or any teaching that is directly done on the staff. So I'm going to review that very briefly. When the client is asking the question, I had a partner, I bought the shares from that partner who was leaving, and I'm now going to sell those shares to a new partner. This is what we're doing right now. What do I have to worry about? So he's asking you the question. And I think the first issue that you have to think about is that if the shares being sold are 50%, then a number of issues that should go through your mind actually, which are, for example, you have 51% that many people in business have figured out that gives you controlling interest. How does it give you controlling interest? Is because you have a right to elect the board of directors by majority. And how does a majority work? It works by a percentage majority. That is also something never taught in any of the schools or programs that I've listened to. So let me just go through the principle of majority in shareholding. If you have 1,000 shares issued in the company from Treasury, and you have 500 is exactly half of that number. If you have 500, you have one shareholder who owns 500. You can take any number. You have 70 shares, 35 owned by one shareholder, and 35 owned by another shareholder, then you have a conflict which you have to resolve. How are you going to resolve the conflict? Business Corporations Act does not say anything about how to resolve the conflict. It only tells you who can draft the resolution. There's a whole two different sections in Business Corporations Act of both Canada and Ontario that simply prescribes that directors only have the right to do the share transfer. So when you prepare the resolution in a minute book that looks like this, you have to really make sure that the resolution is that of directors and not shareholders, actually. When the shareholders come in the picture, which we will deal with in some estate file shortly, actually, because that estate owns some companies. But when that happens, then it's a very different situation, actually. But in general, when you have a minute book where you're asked to prepare a resolution, it is only directors who sign that. If you sell the whole company, it used to be Section 15 of the Business Corporations Act of Ontario that said that you must have the consent of all the shareholders, because they are now affected by the fact that you sell the entire company, which can be by shares or it can be by assets. But either way, you have to get their consent. So you have to be vigilant if you're a buyer's lawyer that you asked for the resolution from the vendor. So I think in my days, we still do it now, that the downtown firms have perfected the checklist of the closing agenda. So I think it is very important to create this agenda in the corporate law to become aware that there are large number of issues that you have to think about. It is much more complicated in terms of the title arrangement in a corporate transactions than it is in real estate. So I think, so I've talked about the purchase agreement, the resolution to transfer the shares, a shareholders agreement, which then gives you the resolution of the problem should there be a dispute. The first question is that if you each had 50% of the shares, not the numbers, number can be 1,000, 10,000, 500, 70, whatever the number. If you had 51%, you have a right of control and a right of dispute. If you get into a dispute between vendor and a purchaser because they can't agree on consistently on a policy. Okay, well, I like my financial statement, which is usually approved by the directors before sending it to the tax department. Then I prefer that we take the depreciation and we will also show this particular amount as a deduction, as an expense, and therefore the financial statement that to lawyer looks like a very solid black and white pursuant to the usual accounting principles and normal document. I would like to sort of tell you my view that is not as rigid and black and white as it appears on the face of it, because there is an accountant's discretion that is used to try to describe what is deductible. If you have a car, for example, you use the car 90% of the time, 75% of the time, there are criteria, usually 75% for office use and 25% your personal use. So these decisions on the percentages and how much of the cost of the car is deductible is discretionary and in the judgment of the person who is actually submitting tax return to the government. But very often the accountant suggested, some accountants are good and they explain it to you. Some accountants are not good. But let me tell you the role of the lawyer actually. We have to be one step ahead of the accountant as well, actually. And most of us are not actually, because accounting we consider to be something that is not our domain, and therefore we don't deal with it. But I think if you do corporate law, in the long run, you will have to understand the financial statement. And I hated numbers. And by the way, Amna was in the LSC, and every subject dealing with accounting and statistics, I avoided. And I got my whole degree, by the way, but without the accounting, without the logic and anything that to do with the numbers. So when it came to being called to the bar, I had to ask an accountant in Newmarket to sit with me every weekend and for about a year and a half until I understood the principles of profit and loss, assets and liabilities. And those who want to practice like Kevin in the corporate law area, I think I urge you to understand. And I think if any of you feel that we need to understand the basic principles and how it affects the sale of shares, I will illustrate a couple of issues, but there will not be enough time. to talk about the accounting issues themselves because it's a whole separate discipline, but we need to be able to work with an accountant. So I strongly recommend to all of you that if you are writing a report to the client or drafting a document, it is important and very important that you do not take over the responsibility, because even the accounting language at some point in time, meaning the numbering system, if it doesn't fall correctly, right up to a lot of the trial level at the tax revenue tax court, as they call it, is done by the accountants. But if it goes to higher court and in the federal court for appeal, it'll end up with the lawyer. So the lawyer there becomes a specialized lawyer. He understands accounting as well as the law, but the accountant does not. So there is a certain amount of overlapping of the two professions. But I strongly recommend that if you're doing a transaction of purchase or the sale of shares, that this transaction you shift the responsibility to the accountant. How do you do that? You tell the client in your retainer or in a reporting letter that I'm only responsible for the legal aspects of this transaction, and that you will seek the accountant's advice. And if required, you have to keep in mind always, and I have managed my practice all these years without negligence or professional incompetence. And the way I did it was you measure it not just from the legal point of view of the knowledge, but also what would happen if something went wrong. I guess just give an example. Like typically what goes wrong, you should observe that, not just your own transaction. Typically in a sale of shares, what happens is the purchaser starts a business and then suddenly finds that he is not managing the business as efficiently as the vendor did and blames the lawyer. So you now have a situation of negligence that you didn't tell me to put the financial statements, you didn't tell me to look at the accounting statements properly, so you were negligent, liable. So he's the first person. So every time when we do work as a lawyer, we have to cover our situation not from the point of view of rejoicing the day you close the deal, but the day that you are sure in your mind that all potential risk elements have been covered by the lawyer actually. And how do you cover it actually? Both in real estate, Naman, what my system was, that you actually write, which is also not in the program of TerraView and also lawyer done deal types of programs actually, that you have a client acknowledgement. We are not superhuman that we guarantee. Like our certificates of title used to be like this one. I certify, it used to be wording like that one. I certify that you have a good and a marketable title. That's the wording also used by the insurance companies actually. And they force you to write that if you're doing real estate and refinancing arrangement. So I think how do you overcome that? You overcome that by shifting the responsibilities to the client as well as to the accountant whenever possible. So let me give you an example in the transaction that we're doing, Ikra, now. So say, for example, we'll be acting for the vendor, and then we will be acting for the purchaser. And what do we cover actually? We will tell the client in our agreement, if possible, or in a letter to the effect that you will be consulting your accountant and I will not take the responsibility for the capital gains tax, for example. The shares are capital asset. If you buy the capital asset of the shares, the tax is imposed on the gain that is made. How do you measure the gain? You should also know, based on the case law of the tax department, that the gain that is made is in a small company very often dependent upon the amount, the kind of information you gathered from other people, such as what does the company of a typical type sell for. So if you have a grocery store, a hairdressing shop, if you have a heavy industry, then there are different valuation systems, which I won't go through right now, but there are different ways of assessing a typical business and seeing how they are evaluated for the purchase purposes actually. So I think the best thing is for the lawyer to exclude himself from the responsibility of the capital gains tax as well as the financial statement itself also. That, okay, when he comes to sign the documents, as between the date of the signing of the purchase agreement, the date of closing, some of the clients will not even know the distinction. And I have gone through it several times. You have to explain to the client that the reason why there is a time gap between the agreement being signed and the date of the closing is because the purchaser's lawyer wants to then check out the various representations you made by searching PPSA, even bankruptcy in some cases, and the judgments against the vendor, etc., for the purpose of certifying the purchaser's title to the shares. So you want to watch those events and then make sure that the shares are clear, and then you are able to give a certificate of title. So there is a time frame of about a month or 3 weeks between the date of the agreement and the date of closing. And the date of closing, you have a whole checklist of the documents that you're going to present, and the vendor is a column. I will give you a resolution. I'll give you the shareholders agreement. So I think I mentioned to you, we are still on the topic of the documents you need. So one way to shorten the learning problem, and this is the problem that I'm going through, the learning problem in the school is so far different, if you like, or deficient from the actual practice that I want to address the lectures or the talks from the point of view of what do you need to know to have a good practice successful without liability, and you're able to track the clients and say, yes, you're knowledgeable. Actually, that's the objective of my exercise that I'm going through with all of you, actually. So I think I want to just summarize that what am I doing and how am I doing it? So in this particular case, Ikra, let me address it to you, that how do we do the documents between us as the vendor's lawyer and the purchaser's lawyer, which will be Lovey in this case, actually. So these are, firstly, in the common law system, you have to have independent lawyer for each particular party, the vendor's interest and the purchaser's interest. There are 2 different interests. So that's why you need 2 different lawyers. Some lawyers will interpret. There is no discussion or in any papers that I have read so far in my almost 48 or 50 years of practice, is that explaining the degree of conflict. Do you then talk to the other lawyer and say, hello, Mr. or Miss so-and-so, I want to tell you that I'm the lawyer of the vendor, you're the lawyer of the purchaser, and I will have these documents prepared, and I am a little concerned about the wording. Can you prepare it? What has happened in the computer days, this is an interest, Adran, actually. What has happened, Adran, in the computer days is that the distinction that historically existed between the obligation of the vendor to provide the documentation, let's say real estate, the deed. In the case of the minute book, if I am the vendor's lawyer, this minute book is where I have the record. It's the only record that exists. The government doesn't carry the record, except the record of the directors by way of a notice. So the vendor traditionally prepared the resolution because he had an idea in his mind that this resolution will show the current directors and shareholders, and therefore he prepared the resolution in draft form and gave it to the purchaser's lawyer. But because of the computer days, you have instant templates which you can use to immediately say, well, Mr. Vendor, before you prepare it, I can use my precedent and give it to you. So in drafting, what has happened is that the roles of the vendor purchase lawyers is slightly blurred in terms of who does the document. For example, a shareholders agreement. In the shareholders agreement, either the vendor prepares it or the purchaser. It doesn't make too much difference because it's going to affect the purchaser also to the extent of his share ownership. The share ownership is 50-50. You have to have a unanimous shareholders agreement so that everybody agreed to the shareholders agreement, which becomes binding with respect to everything said there and can override even the bylaws of the corporation. So it is very important to make sure that the document is prepared by the lawyer according to their comfort level. If you're organized like you are, Adran, in terms of computers, you carry precedence. I am also carrying a whole set of precedents so that I just take the precedent, and if I have a doubt in my mind, I know my wording, I just send it to the other lawyer. Do you agree? And the chances are that it's very organized, that the other lawyer in a smaller practice will have his own, will accept your document. If you hit upon a big lawyer downtown, then he will have a different idea. So he might change your documents and say, I want to change the following things. So I think so. Just to summarize again, What are the documents?
Sorry, sir, to cut you off. It's just, I think someone, I think it's Mr. Conley. It's hard for me to hear you because there's like a lot of like noise coming in from the side.
Yeah, Chaitanya, are you there now?
Yes, yes, I'm here.
Can you
Oh,
hear me?
there we go.
Okay, I'm here.
Good. Okay, so is there a noise now, Ikra?
Not at the moment, but a little bit. It comes and goes. I think if everyone shuts their mics off while you're speaking, it might help.
Yeah, Mr. Campbell, can you see to shut off your mic or mute it because we're hearing the vehicles in the background.
Yeah, okay, I'm driving right now. Okay, let me see. Okay,
If you just mute your microphone, then it will lessen the noise, Chaitanya.
okay. But let me call you back. Let me join again then. Okay,
Yeah.
I'm leaving right now.
Okay.
So I just summarize again, Ikra, the documents that you need in a share transfer.
Just give me 1 second. I'm leaving it.
Share purchase agreement, resolution, shareholders agreement, are the primary documents. But it's better to have even the retainer and the reporting letter. So they're part of the precedent. So you can give a precedence, and this is how I am doing my files. You take the whole set of precedents, give it to the lawyer or the student, they do the documents, and then give the other lawyer to approve. They approve, and then you have a closing date on which you close. Now, the sequencing of the events that you need to do in a share purchase agreement is also not taught in the school. So very often a new lawyer will end up trying to worry, and in quite a number of procedures I saw, simply worrying actually, what do I do next? What do I do next? So I think that it is very important to just understand the major sequence: the agreement, the documents, closing date, agenda for the closing, and a date of closing. And why the date of closing is important? Because there is a law of tender actually, that if you agreed in real estate or corporate law, a date of closing, the obligation of the vendor to present the documents and receive the money is the date that is stipulated in the agreement actually. So it is very important. So if you're dealing with a lawyer on the other side that you know, we would not have to worry because you know the other lawyer and they will adjust to the date. If not, you can end up have a whole trial on the issue who was at fault for not providing their part of the obligation, either money as a purchaser to the vendor or documents that the vendor is required to give to convey good title to the purchaser. So I think I've summarized basically the documents. It includes the share certificate and the register. So just to give you an idea, in the minute book here, you will see that at the back of you prepare the resolution. Technically, it's the resolution that is the binding portion of the document. So, and the wording is never taught in any of the seminars that I'm aware of actually. So that you say, be it resolved, and then a semicolon, and then say, the vendor AB hereby conveys 50 shares to the purchaser. And when you say that and everybody has signed it, then you make a record in your shareholders register at the back of the minute book. And the computer days, what has happened, Adran, is that this is all capable of being done now. I got mine done with Payman not too long ago, that you can have the entire share certificate now done on the computer. You can just print it out. And I have still not organized them in the terms of the document point of view. But I think the requirement of the minute book has still not disappeared from the record keeping. So in other words, you can't just keep a record on the computer and say that I have done my documents that are sitting on the computer. When I need it, I'll print it. The minute book requirements of what you need to do is set out in the Business Corporations Act. And there is a whole list of things that you're required to do. And it comes in different sections. And when you're practicing, you're required to get to know these sections and deal with them more thoroughly than you would in the theory of the law when you do the exam, actually. So I think that summarize now, the main documents you need to do the conveyancing, namely the purchase agreement, the resolutions, the registers in the back, the share certificates. So suppose you transferred 50 shares out of the 100 and the new buyer has the 50 shares, then you issue the new share certificate for 50 common shares. And I won't go through today to explain actually the different types of shares. So you have to make sure that the shares are all common, and most of the time they are common. the distinction between the common share ownership, where you can vote for the directors, and other shares which are special or preferred, where you may not even have a right to vote. So what is important is to note what kind of shares are you, and these share certificates are also stored in the back of it. So you report into the client that these are the shares that are being transferred from the vendor to the purchaser, make a register, what do you call a record in the register at the back of the minute book. And most importantly, the way it really hits the lawyer again is that somebody in the office forgot to write a notice to the ministry. So just to summarize, the government does not keep in Canada the record as it does in some other countries of who the shareholders are. And therefore, the tax department may get to know from what you say to them for the dividend declaration or what you paid as a tax in terms of dividends. But apart from that, the minute book is entirely a private record. But there is a requirement that within so many days, you will give the notice to the ministry to say who was the director and what are the new directors' names, because there's a whole set of laws that have tried to impinge upon the historical limited liability concept that was so fundamental in the common law, actually, which limited liability and exposure to personal liability of the person by forming the company. So when you're buying shares, the most important principle to keep in mind is that the legal entity remains the legal entity. Shares are the way to control the directors and basically affect the decisions on the financial statement through the year, through the directors. At the end of the year, there's another shareholders meeting in which you then approve the financial statement, but that statement belongs to the company. So there are two legal persons in the law. One is the corporation, and the second one is the person who is over the age of 18 years. So it's very important that the law recognizes the limited liability throughout. And these two persons can have a standing in the court system, it can have a liability, it can have obligations of tax, etc. So when you sell the shares, the fundamental principle to keep in mind is that the corporation remains a separate entity. Now, this also creates the next issue that I want to deal with is the common law responsibility of each person to deal with the responsibility they have for protecting the client's interest. If you're a vendor's lawyer, to protect the vendor. If you purchase a lawyer, to protect the purchaser. So there are independent legal representation, which is mentioned in the rules of professional conduct as well, that ILA, and some lawyers will do that actually, that to minimize the cost, a lot of the documentation is repeated in a small company. So you say simply that an independent lawyer will simply approve them from the ILA point of view, meaning independent legal advice point of view. If you represent the client, as the rules of professional conduct tell you, then you have to be involved in the whole transaction. You negotiated, you agreed, you participated in the wording and interacted with the vendor's lawyer to reach a conclusion that your client's purchaser is protected. So the next issue after the agreement and the document preparation is the closing date. On the closing date, you exchange the documents against the money. So if you get the money, there's very little in the bar materials actually that did he give a promissory note? Did he give a tangible check, which then basically means that you depend on the credibility of the purchaser to say that I stand behind the promissory note and will pay it. If the check doesn't cash, you go to court. If you go to court and then you try to prove that you have a judgment, you lost 6 months, 1 year, or you had a summary judgment, whatever, then you lost a long time to prove that you collect. So what you have to do as a vendor's lawyer is the protection of your client to ensuring that you have a certified check or a tangible security. So if there is a security is covered by PPSA, then you also have to make sure that the PPSA is registered against the title as well. So these are the obligations of the two lawyers, the vendor and purchaser, on the sale of shares. So So I think that, any questions on that issue so far? If not, then I move ahead. Feel free to
Sorry,
ask.
sir, I didn't really understand what you were saying that the notice to the ministry was important for. You said there was a requirement to send notice.
Yeah.
The ministry, was that with regards to reporting the shares or any changes in the directors? Sorry, I missed that part.
The notice of ministry is a form, and it's only for the directors, not shareholders.
Directors, okay, thank you.
And I think, you see, I mean, if you want to dig into that particular provisions, that is an obligation actually, that you will do that part. And if you look at another part of the Business Corporations Act down the line, that if you don't comply with the different provisions of the statute, then you're committing an offense. You see that? But I have never seen anybody being prosecuted for not giving the information to the ministry. So what typically happens is that even if you cross the time limit within which they want you to send the notice to the ministry, there is usually no sanctions against it actually. So most of the people, as a part of the procedure in an organized law firm doing corporate law, will make it a part of the routine to create a notice and send it to the ministry, and then have it, and then very often, what I used to do in the days when the post office was working effectively, now it's all computerized, that you simply send a notice in writing and keep a rubber stamp copy in the office in the file. But I think that recently I noticed that the record of the directors is also, I think it is in the federal companies, being changed directly from your computer. So you can change with a password the name of the director. So the notice not only reaches there, it shows the name of the new director and the name of the new director who takes the responsibility for a director. So there won't be enough time to go through the director's liability today. And if anybody is interested, then we will go through that. But there are a lot of statutes that have been enacted that makes the director liable. Just give you one example of it, is that you must file your tax return as a corporation. So that liability is that of the corporation, but the filing itself is the responsibility of the director. So these kind of statutes have created responsibility for the directors to carry out what they do for the corporation. So I think that why would you, I think, any questions, any other questions, Ikra? But she's gone, So I just want to.
Sorry, me, sir? No, I'm done.
Okay, so let me just carry on. And then I think the next few minutes we'll conclude the whole thing. And if any other questions, I would like to answer them. But I think that why a shareholders agreement, it becomes a part of the advice to the client at the time when you transfer the shares, is because if you have a shareholders agreement, it creates a mechanism for resolution of the dispute between the shareholders. If you do not, I just want to summarize to you that the person without a shareholders agreement will end up asking for a winding up. There's nothing in the bar admission notes or anywhere that I've seen in typical seminars on what happens if you ask for winding up. It's very important to know. It's just based on practice that if you wind up the corporation, make an application, you can imagine that nobody knows what the outcome of the judge will be to wind up. The commercial court in Toronto will be dealing with that is for the bigger companies. And you can do a statement of claim for minority shareholder rights, etc., in a smaller company. But in essence, the fact that you are trying to resolve the issue by winding it up in the legal sense and asking for, there's a procedure for that, winding up. If you ask for a winding up procedure, then you will see that the winding up procedure will take so long that all the shareholders will lose interest in the company. There is no financial statement, there is no income. And by the time you reach the court, the landlord has not been paid, there's no profit, no employees, and nothing to wind up, right? So I think that part, that if you do not have a shareholders agreement, that you will end up basically having a dispute. I had one in Richmond Hill, actually, that the two shareholders were fighting. And I think that I had just give you my personal experience, actually, that a lawyer on the other side, first he was a corporate lawyer, then they decided that we should just have a litigation lawyer to fight this out. And then what I did was I simply changed and said that we would get the old company go defunct, actually. And all the litigation would go and remain with the defunct company. And I outwitted the other lawyer, actually. And he even congratulated me, actually. But I think that it's very important that when you're doing a specialty and say, I'm a corporate lawyer, I do nothing but corporate law. I'm very proud of the fact that I know corporate law. But if you don't know litigation, is a good example, Naman, is a new example that there were 3 sets of lawyers in this particular situation, all of them. And in the last one, even congratulated me in his boardroom once. He said, oh, if we fight the winding up of a company, there's no asset there. I said, that's correct. So why fight actually about it? So I think that if you understand the corporate law and also litigation, you'll have an advantage in terms of how you negotiate the resolution with the other lawyer. And I think you give them notice. So I think in this particular case, it actually happened. So we had, I think that clients, by not having shareholders agreement, my recollection is that we had billed the client between $40,000 to $60,000 actually by the time we went through many, many steps. And each litigation lawyer thought, and the clients on the other side thought that if we use the big hammer of the court system and hammer down our proposed resolution, that they should follow. But I think that they pay huge amounts of fees. But what can you do actually? Just a side note to the whole discussion is that a part of our obligation, never emphasized sufficiently in education, is to educate the client. And education of the client is different than the advice to the client. Because what you're doing by educating the client is to give them not only the tool to make a good decision with, because most people you will see as clients do not have the feel, and many people, especially immigrants who are not in tune with the legal system, they will tend to make the decision based on the cultural norm of this society. For example, if you're Indian, I'm employed in India, registered in Indian jurisdiction, by the way, so I do know the Indian jurisdiction. And Naman is in Punjab. I'm registered in Gujarat. So if you have, let's say, a Gujarati client, and they have to make a decision, what they will try to do is to make a decision to avoid the court system. But if you have the practice knowledge of the Ontario jurisdiction, you know that when you do reach the judge in the court, you will have an effective decision based on the principles of law. And the Indian client will have difficulty grasping that. So what you do, you educate the client, but you cannot change the attitude. So what I'm watching more recent years since I'm lecturing, that the changing of the client's issues and attitudes and learning of what they should do and educating them is different than giving legal advice. The legal advice can say, for example, you need a shareholders agreement. He immediately thinks in his mind, how much does it cost? He's more concerned about the cost. If you say $2,000, oh, no, we'll postpone it. So quite a few companies, and I've got 100, 200 companies with me on my shelf in the office, but a huge number do not have a shareholders agreement. And the reason for that is that there is a cost. So education alone is not sufficient. So what can we do as lawyers? So my feeling is that in our group, at least my recommendation to all of you is that you take some trouble trying to educate the client in addition to advise the client, and then leave it to them to make a decision. But when you do, you document that actually in terms of the retainer, in terms of reporting letter, and even when they come to sign the document for the transfer of shares or whatever it is actually, And so when you do the motel purchase, I would also suggest to you that you have a system for real estate as well, which I'm going to recommend to our group as well, that you have an acknowledgement system that I've looked at the title, I've looked at statement of adjustments, I've looked at the documents in the share purchase, and I have read the wording, and you leave it to them. They've read it or not is their problem. But after doing what you can, you let them acknowledge that. So I think that is the conclusion of my more or less issue that I want to bring up. And I think that I want to just, if there's any question, I'll answer now. And then my last topic is the tax issues on the share transfer. So any questions? No questions, actually. So I just want to summarize by saying that there are in the share purchase transaction, there are tax issues. How do they arise actually? The share is a capital asset. So when you transfer, the original purchase of the share has a cost base to that one. So if you issued the shares from the treasury, there is $1 each that I allocate. The rest of the capital of the company will come from the loan arrangement, and I recommend loan arrangement. So if the client is not borrowing from the bank, then the loan arrangement works better because you can pay the money back of the loan without tax. Whereas if you pay money back, which has become capital on the financial statement, then that return of the capital through salary to the directors and dividends is taxed at a different bracket. So these are the issues that you have to deal with. And I think it is important for the lawyer to understand sufficient amount of the fact that the dividends will be taxed lower than your salary. If you give the salary, so I just leave it to the accountant, but I think we as lawyers should know what are the tax implications of a salary as against the dividend. And if you do an employment contract, that many small companies will have a director who also works as an employee, he works as in all the different capacities, and all the payments you make in different capacities may have a different tax implications actually. So I think you leave it to the accountant, but we should understand sufficient amount to make sure that we have done our part. And when you do the report, you shift the responsibility to the accountant for doing the thing. So I think that if there are no questions, and I will just move to the last issue. How do you make money? And that is the most important part, in that I don't see any lecture, Ikra is smiling, on the question, Ikra, of how to make money from the corporate law. Why am I suggesting to all of you that you can see from this seminar actually that there are a lot of little nitty-gritty, and any one of them can become serious if it is not addressed properly. So I think that important thing is that if you do the resolution, for example, in this particular situation, I quoted the fee to the client, which is extremely modest, by the way, if you compare it with the downtown. So what is a typical downtown fee? If you have a typical shareholders agreement, $2,000 to $3,000 actually, if you have a resolution to transfer $1,000, so you may have a $3,000 to $5,000 budget when you're doing a share transfer agreement actually. But so next question is that when you do a shareholders agreement, who are you acting for, right? If you have two different lawyers, then a lawyer for the vendor, lawyer for the purchaser, who is acting for the company? So in the common law system, that question is very vital actually, that did you take the responsibility for the corporation and protecting the corporation itself? So your reporting letter should indicate that I acted only for the vendor or the company. And if you're preparing nothing but the shareholders agreement, then the safer thing to do is to act for the corporation and then get the acknowledgement from each shareholder that they got independent legal advice if they wanted to have it. So that gets you out of the responsibilities of trying to take on the what's so-called joint retainer. There's a big chapter on the joint retainer. So the only time I would recommend that the joint retainer be undertaken is the situation where you identify your interest to the vendor in this transaction between the corporate interest and the interest of the shareholder, and then the interest of the corporation. So you only represent those institutions where you are comfortable that there is a kind of a common interest of the person and the company at the same time, and then you can act for the two parties. But I think in terms of legal fees, actually, usually if you build the company, it is better actually because the company can deduct it from their budget and pay it to you and show it in their financial statement as an expense, and therefore it becomes easier. So coming to fees, it is very important that you point out to the client that the fees are deductible and therefore they can afford more fees, and the companies usually have a better budget than the individuals actually. So that's the reason why it is important to try to act for the company whenever possible and make the fees deductible. The tax department, even if you were acting for the vendor and they paid it from the company, I think the chances of the tax department questioning is very small in my view, but depends on how big the transaction was and what is it that you were doing and whether it was for the person or the company. It's very important. So that concludes my different topic that I want to cover. And I'd like to open the door to anybody who has a question. Any question, Adron?
No questions?
No? No one?
No, sir.
No, so just a comment to you, when we do the motel purchase, we will deal with the issues separately. So let me just see Dean, if he doesn't, his mic doesn't work. Kevin, any
None
question
from
you
me.
have?
None from me, thanks.
Thank you, Jay. I joined late, but I really enjoyed the conversation. This is Gulwark. Thank you.
Gul, so I'm going to close off the voice and then talk to you, Gul, actually. So,
Of course, anytime.
okay.
Yes,
So let me
thank you.
just-
I enjoyed the conversation. Thank you so much.